We're going to get started with the last panel of the day. And really pleased to introduce and looking forward to the discussion, Insider Trading, 360 Degrees, Enforcement Trends, Key Cases, and Prosecutions. Our moderator is Poonam Kumar, partner at Gibson, based here in LA. She's a former federal prosecutor. We're joined by Colleen Keating from the Los Angeles Regional Office, where she's senior counsel. And we're rounding things out with Jamie Lang, a partner at King & Spalding. And prior to her time at King & Spalding, Jamie was in AUSA here in CD Cal. Welcome, Jamie. And then Jennifer Marietta-Westberg, vice president at Cornerstone, who has a wealth of experience as a testifying expert and is a former member of the SEC's Division of Economic and Risk Analysis. I think our one DIRA representative today. So, take it away.
Great. Thanks, everyone. So nice to be here. I know we are the last thing between you and the cocktail hour, so I promise we will be riveting and exciting and also get you out potentially a little earlier so you can be on your merry way. We're really excited to be here to talk about enforcement trends, key cases in the insider trading space, and what that's going to look like in the near future. So I think we're going to kick it off, and I'm going to start with Colleen. She's going to give us a little bit of an overview of some of the cases we've already seen since January of 2025, and sort of see if they are new, different, similar to what we've seen before. So Colleen, kick it off.
Sure. So I have to begin, and this is the last time you're going to hear this today. My remarks are provided in my official capacity as senior counsel in the Division of Enforcement, but they do not necessarily reflect the view of the commissioners, or my colleagues on the staff. So you've heard throughout today that this is a period of transition. But when it comes to insider trading, in my view, this is really one of our bread and butter areas, and we're going to continue to bring these types of cases. We tend to see insider trading around the same types of market-moving events. So, this isn't an exclusive list, but often they're around quarterly and yearly earnings, mergers and acquisitions, and for pharmaceutical companies, clinical trial results or FDA decisions. C-suite defendants often get the most press, but we do see insider trading up and down the corporate hierarchy, as well as outside of that chain of command, as a few of the cases I'm going to talk about so far will demonstrate. So the first matter I want to highlight is SEC versus Safi et al. This was filed in March of this year in the District of Massachusetts. We charged 2 foreign traders for their alleged involvement in an international insider trading ring that generated millions of dollars in illicit profits from trading in advance of market-moving announcements between 2017 and 2024. The complaint alleged that Safi obtained MNPI from insiders, and he tipped another trader, Giga, who was also named as a defendant. And there was a third trader, a US-based trader, who was called Trader A in the complaint. That individual was not charged in this complaint. These 3 individuals collectively made more than $17.5 million by trading on MNPI in advance of 10 different corporate announcements. As alleged in the complaint, Safi demanded and received kickbacks from Trader A. And at one point, Trader A allegedly traveled from the Czech Republic to Vienna to meet Safi in a cafe to deliver a bag containing $100,000 in cash. Safi also paid his insider sources. And I thought this was an interesting point in the complaint. We also alleged that Safi leaked MNPI to the press so that he could profitably trade around the publication of that information, as opposed to waiting to potentially profit from a corporate announcement. So to me, this case illustrates some of the challenges that the staff have to face in investigating insider trading. We had foreign traders who used disappearing messages, Signal and Telegram, and they used burner phones to communicate. We also alleged in the complaint that defendants used coded language to communicate in these apps. So for example, they disguised communications about public issuers as conversations about women or girlfriends. So Kindred, for example, an issuer became Kelly in their chats. So for the same reason, to me, this case really illustrates the doggedness and the determination of the staff to root out this type of wrongdoing. And I would also note that Safi and Go were criminally indicted in the District of Massachusetts by the U.S. Attorney's Office there. The second case I wanted to highlight is SEC versus Demos. This was also filed in March of this year. And in this matter, we charged George Demos, who was a former VP of Drug Safety at Acadia Pharmaceuticals, for insider trading in advance of Acadia's March 8, 2021 announcement of an adverse decision from the FDA regarding Acadia's supplemental new drug application. The FDA had notified Acadia that it would communicate its own proposed labeling for the drug by March 3rd if no major deficiencies were identified in the application. And Acadia did not announce this fact publicly. But Demos was a core member of Acadia's labeling team, and he knew of this March 3rd date by which the FDA was going to communicate the labeling. He also knew that the labeling team was scheduled to meet on March 4th to discuss. On March 3rd, the FDA notified Acadia that the proposed labeling was not forthcoming because the FDA had identified deficiencies in the application. We did not allege that Demos was aware of this fact. However, he did know March 3rd came and went without the label from the FDA. And he also knew that the March 4th meeting that had been scheduled for the labeling team to discuss was postponed to March 5th because he was told that Acadia's management was not quite ready to discuss the FDA's feedback. That meeting of the labeling team continued to be postponed, canceled, and rescheduled over the next several days. And again, to me, this is another case with challenging facts because we had pointed to the fact that, Demos was aware of the fact that March 3rd came and went and the rescheduling of this meeting. And from that, that was the NPI. And from that, he inferred that the FDA's decision on the drug application was an adverse one. On the morning of March 8th, he exercised nearly all of his vested stock options and immediately sold his shares. Less than 3 hours after he sold his shares, Acadia announced that the FDA had identified deficiencies in its application. And the next day, Acadia's stock price closed down 45%. So by trading on MNPI, Demos had avoided losses about $1.3 million. Demos was also criminally charged by the U.S. Attorney's Office for the Southern District of California. He pleaded guilty, and he agreed to forfeit about $1.3 million. And his sentencing is scheduled for later this month. One more thing to flag about the SEC case there, he agreed to a 5-year officer and director bar with monetary remedies to be determined by the court. And then the last case that I wanted to flag is SEC versus Tobia. This was filed in January of this year. Tobia was the president and chief investment officer of a public issuer that we called Company A. And he tipped his sister-in-law, Lee, on multiple occasions. She traded on the MNPI and netted more than $425,000 in unlawful profits. So on one occasion, he tipped his sister-in-law about his own company's plan to make an offer to acquire Spock Holdings. The sister-in-law purchased Spock stock and then sold it after the deal was announced. Tobia was also on the board of directors of a second public company, which we identified as Company B in the complaint. And in that role, he was in communication with a director of another public company, PFS Web, to discuss a potential transaction between Company B and PFS Web. And during that call, he learned of the planned sale of one of PFS Web's business units. So he tipped his sister-in-law that information, and she purchased PFS Web stock and sold it after the transaction was announced. This was filed as a settled action, and Tobia agreed to a 5-year O&D bar. And I flagged this case because, the facts are a little bit less juicy. There's no bag of cash involved, but I think it shows that We will pursue cases where an insider misuses information for the benefit of others.
Yeah, it seems like these 3 cases highlight some of the things that the commission has always done. Cases that talk about, tipping to your relative or to someone out in your circle. Also cases involving, like you said at the beginning, specific market events. I thought the Softy case was particularly interesting because it was a 7-year long scheme, a little bit different than the traditional cases, multiple different pieces of MNPI. Definitely more of a ring. I think the cash probably confirms that part of it. But I know, Jennifer, you also have some data, as you would as an economist, to talk a little bit about the things that you've seen in the past few years and then even in this fiscal year for the commission.
Sure. So we thought it would be interesting to track the numbers of the trends in insider trading enforcement actions. And in particular, we went back to the Trump 1.0 under Chair Clayton, looked at those 4 fiscal years, compared them with the Biden administration under Chair Gensler. And maybe not surprising, because these are kind of bread and butter cases for the SEC, that the numbers are really similar. So under Chair Clayton, those 4 fiscal years, the average was 38 actions each year. Under Gensler, the average was 34 actions per year. So very similar. Now, what's quite interesting is since October 1st of 2024, so starting the fiscal year 2025, there have already been 31 actions. And that has split out with 19 actions between October 1st, 2024, right until the day before Trump's inauguration. So 19 there, but 12 since January 22nd of this year up until April 30th. So in total, 31 actions. And if we were extrapolating those out through the rest of fiscal year 2025, that would indicate one of the larger accounts that we've seen going back the last 10, 12 years. So there does seem to be a lot of activity. And then just looking again at the Chair Clayton versus Chair Gensler, a couple of other metrics. Most actions, not surprisingly, involve a single stock. Those are the larger percentages. But in the later Gensler years, there were a growing percentage of cases that involved multiple stocks in terms of the allegations. And then also similarities we see in terms of where the actions are brought in which district. Not surprisingly, the Southern District of New York has by far the largest number of actions under either administration. An order of magnitude lower than those, the next 3 are the districts of California, New Jersey, and Massachusetts.
So maybe some optimism or cynicism, depending on your side, about what may happen in the next few years in the insider trading world. The next thing we wanted to talk about are 10b5-1 cases. I think all of you are familiar with what those are. 10b5-1 plans were sort of started as a way of inoculating or protecting executives from potential prosecution from insider trading or other market manipulation allegations. But there have been a few, and one most recently, a case against Taryn Pizer for trading, even though there was a 10b5 plan in place. Jamie was defense counsel along with her colleague at Spalding in this case. Jamie, maybe you could just start to give us a little bit of a high-level overview of the case, but then also talk a little bit about what you've learned about this process and your takeaways from the defense.
Yeah, so I assume basic facts are known to a number of you here, but just as a general matter, in 2023, DOJ filed charges against the former CEO of OnTrack, our client, Taryn Pizer, alleging that he had avoided more than $12 million in losses by entering into 2 10b5-1 plans while he was in possession of MNPI about the status of one of his company's largest customers leaving and terminating the contract. So we did go to trial in this in June. We lost, but we're going to keep fighting. We came in second. It's a good one. I'll do that. And it was a tough case, and I did think it would be interesting to talk through just some of the more particular facts of the case and some things we saw in terms of how the government was approaching proving the case up at trial, how we're going into sentencing a little bit as well, sentencing scheduled for the end of next month in June. So, as Poonam said, this is not your typical insider trading case. This was not one where Mr. Pizer was acting unilaterally or clandestinely. Prior to executing both plans, amongst other things, he sought approval to enter into the plans from the chief insider trading compliance officer at the company, who was also the CFO. He also filed the requisite SEC forms. We filed the Schedule 13Ds. We filed the Form 4s, sort of disclosing the existence of the plans and how the trading was going to happen. This also wasn't a case where there was one sale of stock. The plans had a very gradual sale of the stock over a period of time. What Mr. Pizer's plans did not have was a cooling off period in them. And as I think everyone in this room knows, in December of 2022, the SEC amended Rule 10b5-1 to mandate that you need to have a cooling off period for certain insiders if you're going to start trading and executing these plans. So just meaning you have to wait a little bit before the plan can actually go into execution. At the time that Mr. Pizer entered his plans, that was not the law. And while it was a best practice and highly recommended to do a cooling off period, it was not required. Mr. Pizer did not have a cooling off period. And this was a key argument for the government at trial to prove criminal intent, even though it was not mandated by the law, even though he did not have to do it. And so in our view, this was an example of the government regulating through enforcement, because he was faulted very heavily for not entering into a cooling off period and for violating this rule before it was created, in effect. I think, as I mentioned a little bit ago, one of the key elements here was Mr. Pizer did have his plans approved by the compliance officer at the company. And so because of that, we sought an advice of compliance professionals instruction, which would have told the jury that relying on a professional in this capacity is inconsistent with the unlawful intent to defraud, because you're getting someone to approve, you're seeking approval of it. Unfortunately, the government objected to us getting this jury instruction. The court declined to give it as well. And part of the reasoning, which I thought was instructive, is looking in the Ninth Circuit, there is not an example of an advice of counsel, if you will, case where there's a compliance professional. Obviously, it's advice of counsel if you're an attorney. There's some cases for accountants and tax preparers, but not for compliance professionals. And that's in the Ninth Circuit. There are other circuits where they have expanded the use of the advice of counsel defense, essentially, to professionals. But the court here was very hesitant to expand it beyond this group, and thought that it should be limited to a more formal profession with highly skilled knowledge, training, things akin to a tax preparer or accountant. As you can imagine, there are a lot of implications for this, because if you're going to a compliance officer, whether it's for insider trading or for something else, and you're relying on that person's advice or that person blessing your actions, it's going to be a little challenging. You'd want to say down the road, like, hey, I checked with someone, I had someone who had this role in the organization say this was okay. I would like to inform a jury of this because it helps inform their view of intent. So to be seen how this continues to play out, but that was one thing, that was a big issue in our case as well. Interestingly, too, with respect to the materiality view that the government took at trial. And I think we're going to talk about it a little bit as well in the context of the shadow trading that's going. I think it seems to be an expanding view of what is considered to be material, both by the government and I think by the courts as well, as we saw in the Panama case that we're going to talk about in a little bit. And here, one of the key issues was this customer going to leave on track? And there were two plans that were executed. The first one was executed when there were both were executed when there were ongoing negotiations with this client. And so it becomes a question of, when does it become material that a customer wants to renegotiate a contract? Like, you can have a lot of arguments to say, well, the market shouldn't know that, because what if you disclose that information too early and then the customer ends up staying with the company and now you've created an issue that didn't need to exist? And so it was a real challenge here in terms of, in practical implications, like, the government was very, very expansive view on, as soon as the government, the company and the customer started really questioning the value of the services, like, should that have been disclosed, or did that constitute MNPI? And I think one other thing I will say on this is during trial as well, in the context of determining what is MNPI, the government also suggested that Mr. Pizer should have consulted outside counsel on the MNPI determination. And again, as you can imagine, that's going to be difficult. Things are constantly changing in a company. You're getting new information all the time. And so it was an interesting view in the sense that, if you go to your compliance officer who knows the company, who knows the facts, like you would hope you could rely on that. But there was an argument made that no, you should have consulted with outside counsel on that. So I think these were just some of the views that were, we debated at trial, but I thought would be interesting to sort of highlight for you all as to how the government was portraying and viewing sort of this area of insider trading liability.
Yeah, it's certainly an evolving landscape, and I agree based on what I've seen that the landscape is certainly expanding, or at least the government is taking expansive approaches to it. Another way that Jamie just referenced is the shadow trading case that I'm sure many of you are familiar with, which is the Panelists case up in the Northern District of California. Just to set the stage, you have the normal insider trading fact pattern, right? Insider or somebody tippy of an insider has information, MNPI, about a company, let's say company A, and then goes ahead and stock trades one way or the other, or somehow vis-a-vis company A. The shadow trading, of course, is using information that is MNPI, confidential to company A, to then trade on company's B stock in some way, shape, or form, and whether or not that can be insider trading. Commission took the position that it was. In the Panelists case, he was, in fact, found liable. That case is ongoing, so I won't ask Colleen to comment on it in any way, but it's a really interesting case from my perspective because it is definitely not something that has been thought of before. I don't think it's a traditional landscape. And there are, I would think, a lot of hurdles for the commission that they cleared in this case to sort of prove that this is fits the fact pattern insider trading. Jamie, you just talk through for us in the Pizer case how your position, your thoughts were that the government was expansive. Is this another sign from your perspective that it is?
It seems like it. It seems like at least some courts are agreeing with that and sort of expand this beyond the traditional area of insider trading liability. I think in denying the motion to dismiss in the Northern District, I think the court there endorsed the SEC's argument that was sort of framed as common sense that information about business decisions by a supplier, a purchaser, or a peer can have an impact on a company and therefore be material. That's a very broad view of materiality. So I think going forward, I would encourage, it seems like it would encourage people to be very careful and take a broad view of whether something is material or not. And I think that's just continued to expand. So we saw that in our trial as well. Obviously this is not an easy determination, and I know Jennifer's going to talk a little bit about how you can sort of decide if there's enough of a market connection to information that you have that relates to another company that could trigger this type of shadow liability. And I think it was interesting because in the Panelists case too, there are other factors that came into play in determining materiality. I think the appellate court pointed to the fact that there was trading within 7 minutes of information coming through. So I think you want to keep that in mind and sort of looking at materiality as a whole. Every case is different, and you've got to take the facts as you get them. But I think before I turn it over to Jennifer, obviously this case triggers thoughts on, okay, well, if, as a company, should you be thinking about revising your insider trading policies to make them broader? Should you expand the blackout period so that when there are these significant events, which we were talking about, like acquisitions, clinical trial testing, things like that, that tend to trigger, these types of cases, should there just be a broader blackout period on that? And that's just something, the companies are going to have to figure out as you're going forward and looking at this.
So I'll jump in and talk about some types of analyses that an economic expert might be able to lend to these kinds of cases, and whether some of those may differ across the sort of classical case versus the shadow trading. So first of all, for the material non-public information question, you're probably aware an economist may come in and run an event study to evaluate materiality by looking at statistical significance of stock price movements. But there's more to it as well. The economists may look at analyst reports. What were the analysts focused on? What did they call out in relation to the stock price movements? Was there confounding information released on the same day that could have somehow impacted the stock price? It may be that given this case-specific information at issue that you turn to the academic literature. There was a case one time where the claims were around information about CEO turnover. Well, you can look to the academic literature. Under which conditions do you tend to, on average, see stock price impacts when CEOs turn over? And it depends on the situation. It depends on whether it's voluntary or involuntary and other factors. Now, for the non-public version of it, is the information already publicly available? The economists could potentially help with that. I had a case one time where the information at issue involved a commodity. And for this particular commodity, there were industry reports that came out with a regular period, again and again. And so the information that was allegedly at issue was in these industry reports and available to the public. Sometimes this can happen. We talked about FDA case. There's a whole cottage industry that looks at FDA signals ahead of particular announcements, and sometimes that information can be deemed to be public as well. Now, there was also mention about when is something just an idea versus when does it turn into material non-public information. So maybe from the economic angle, there can be analysis around was there significant uncertainty still financially, economically around this idea. Then another way that you can look at it through the economic lens is trading analysis. So looking at patterns in the trading, is the trading at issue consistent with how this person tended to trade in the past? Sometimes the allegations are all of a sudden the person started trading options, they'd never traded options, or they never traded in this industry. So you can look at patterns, similar size trades, and really from a statistical significance analysis, can that shed light on the material non-public information question? And then for the shadow insider trading analysis, some of these classical analyses I mentioned, like looking at the trading patterns, is the trading happening around this time that the alleged information is being released? So those kinds of analyses can still be helpful. But then for the classical case, you're looking at the piece of information that the trader acquires is in the same security that they're trading. If instead they acquire a piece of information and they're trading a competitor, well, what can you determine about the correlation between the stock that you received the information in and the stock that you're actually trading? We do know that stocks tend to co-move within an industry, but the degree of that correlation is not consistent across all industries or even necessarily within all stocks in the industry. So that's at least one of the places that you would turn. And there is an academic literature now that we've seen these shadow insider trading cases that is coming out to analyze exactly these questions.
Yeah, I think it'll be really interesting that market connection is such a unique factor in the shadow trading cases, that there has to be such a close connection between the companies at issue within the industry, or whether some other factor that bridges them together. And so it would seem to be a unique fact pattern that would be presented in the Panawat case, and remains to be seen whether or not the government commission or DOJ or otherwise continue to pursue this. But it's definitely it would seem to me a rife area for an expert to sort of really be able to dig in and find other ways to separate the companies and from each other and from the industry. I think there's a lot to be seen about where we are headed in the next few years. But one of the big things we always talk about when we talk about security cases, and I know you all have talked about this in the course of today, but is about parallel proceedings. So DOJ, SEC, there's obviously a lot to talk about in terms of where things are headed and what the Department of Justice is going to be doing in the next few years. We were talking earlier about how here at the U.S. Attorney's Office in the Central District, the corporate securities strike force has been disbanded since the interim United States Attorney was named. Some of them were absorbed by the major fraud section, not to say that they aren't going to do insider trading cases, but what does that mean and how does that look for the future. Colleen, I'd be curious in your work, in your day-to-day work, I know the commission, certainly when I was a prosecutor, worked hand in hand with the SEC every day. How are you, what is the commission's outlook on these kinds of parallel proceedings, and what is your personal view on what we may see?
Well, the two cases that I mentioned earlier, the Safi case and the Demos case, those both had an SEC case and then a parallel DOJ case. Same with the Pizer case. He was criminally charged, and then there was also a parallel SEC investigation and an SEC case against him that's ongoing. So one of the things that Stephen highlighted earlier, we may make referrals to criminal law enforcement. So that's the case in insider trading matters. And this is another thing I think Stephen touched on earlier today, is that we often see complementary remedies in when there's a parallel criminal case and an SEC case. So in addition to SEC remedies, such as we can get an officer and director bar, we've seen robust criminal sentences for insider trading in some cases.
Yeah, it seems to me that certainly folks within the U.S. Attorney's Office and elsewhere in DOJ would certainly still want to bring them. Jamie, what's your view as a practitioner? You think that DOJ is going to be prioritizing these kinds of cases moving forward?
So it'll be interesting. As you mentioned, in LA, there's been disbandment of the strike force that was focusing on these types of cases. I think I was talking with another ASA from the Northern District. I think they've had a similarly less focus on these types of cases and sort of shifting people to other areas of enforcement. I think we all likely read the memo that came out a couple days ago from the head of the criminal division, which outlined, a lot of the department's priorities. And I think some of them weren't really all that much of a surprise, but I think overall there seems to be the tone of there's going to be less focus on your traditional white collar enforcement. And it'll be interesting to see how this plays out in the insider trading case. I mean, in the memo itself, there is a focus on, protecting U.S. investors and making sure that, they're not going to be victimized. But I think that's the focus. It seems to be on those types of cases involving investor fraud, like Ponzi schemes or elder fraud or things like that, where there's really you see the victim, and it's more about taking someone's money as opposed to the market manipulation or things that are more traditional for the insider trading area. So it's going to be interesting to see if the numbers that Jennifer was talking about are going to continue to go forward this year, or if it'll be more focused on the SEC part of it as opposed to not partnering as much with the U.S. Attorney's offices or Main Justice on these.
Yeah, the victim question on the DOJ guidance is definitely going to be interesting, because it's not, I'm sure, the commission, DOJ would not take the position that it's a victimless act. Certainly the market is impacted and there are shareholders impacted, but maybe it changes the way cases are charged, or maybe the way cases are tried, in terms of how the focus of individual victims and folks who are actually feeling the impacts of it. And certainly from an economic point of view, like how many folks, how many people, and what that meant on a individual basis for people who were holding the stock or otherwise participating in the market overall. So I think there's a lot to see. I mean, there's a lot obviously in the news and going on in DC and elsewhere that we'll all be watching, but I think certainly in the insider trading space, I think we can expect to see more movement. I promised we were going to get you out of here early, and I think we have delivered on that promise. Unless anybody's strongly objecting and wants us to keep talking, I think we can let you go early and talk to Cocktail. I know it's been a very long day. Thank you for being here and paying such great attention. We really appreciate it.
Thank you. Great job, Poonam. All right. Thank you all so much. It's been a really great day here in Los Angeles. We have one more thing on the agenda, which is we have a great cocktail party on the roof of this hotel. And if you've never been up there, please just go up there just to see it. But either way, let's go up there. Thank you so much for all of the 35 sponsors for the event. Really appreciate it. Thank you to Secretariat and Morrison and Forster. But let's all head to the roof.